For the uninitiated, understanding the timing of a trust and estate litigation case can be challenging, but before your trial begins, it will be useful to establish realistic timeframes for each step, including court hearings, discovery, potential delays that may occur, and when you can expect to actually have your case heard. This will help you see the big picture of the entire litigation process. First, let's talk about what happens before trial. All trust and estate litigation trials are preceded by several preliminary court hearings. After the petitioner files their petition with the court will give a hearing date for the matter to be heard. This date must be at least 30 days after the date the petition was filed, but is often set for 45 to 90 days later. All interested parties have the right to appear at the hearing and object to the petition. If a party orally objects to the petition, the court usually grants additional time, usually about 45 to 60 days or so, for them to prepare and file a written objection. Next, the court allows time for the parties to conduct discovery, which takes another 3 to 6 months or more. Once it becomes clear that the parties will be unable to reach a resolution on their own, the court will either set a date for the trial or hold a trial-setting conference where a trial date is selected. In total, it can take from 6 to 12 months before you even receive a trial date. In the time of COVID, this can actually take much longer, depending on the county's criminal proceedings, which take precedence over civil matters. Finally, in almost every county in California, you'll be required to participate in a mandatory settlement conference prior to your trial. Again, everything I've covered so far is just leading up to your trial. Once the trial starts, it's important to know that court trials can often have less continuity than jury trials. Court trials are frequently broken up into multiple shorter sessions over the course of several days or even weeks. If a department only hears trials on Friday afternoons, for example, it may take several weeks to complete your trial. Now let's talk about potential delays that may occur. Sometimes delays come from the court. Courts will give preference to a criminal trial. That's because the accused in criminal cases have a constitutional right to a speedy trial, while civil litigants don't have the same rights. Besides the court system, the involved parties and third-party witnesses may also cause delays. For example, if one party refuses to answer discovery properly, then the other party must file discovery motions and ask the court to compel the other party to divulge that information. Taking depositions from third-party witnesses can also cause delays. Take, for example, a witness who's hiding out and trying to avoid being served with a subpoena, or a witness who is itinerant and lacks a permanent address. It takes extra time to track down and serve these kinds of witnesses. If a witness or a party lives outside of California, then you'll need to take extra steps to arrange to take their deposition. Travel, lodging, transportation, and scheduling a court reporter from another jurisdiction to attend all require extra time and planning. So if you were thinking that your California litigation case would be resolved in a few months, you may want to reconsider that notion. From start to finish, a more realistic time frame on a litigation case would be a minimum of a year and possibly a year and a half to 3 years before resolution is reached. When a settlement between two parties does not prove to be possible and a case does go to trial, mindset is everything. The best advice we can offer is to cultivate patience and flexibility and let the process unfold. If you have any questions about trust or estate litigation, please contact our firm. Thanks.
We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.